Hello, everyone. I'm Michele Shuster, and this is my law partner, Chris Weger, and we are very excited to be talking to you about one of those issues that keeps coming up routinely, and we're seeing in a lot of litigation lately. So, really critical topic for us. I will let you know that this is being recorded. It'll be available on our website probably in the next 2 or 3 days. Also, there is a Q&A section that's available within the app. So if you have any questions as we're going along, don't hesitate to put those in there. We should be able to get to all of them before the end of this session, but if not, then Chris or I will reach out to you with responses to those. All right, let's go ahead and get started. Chris, you want to go ahead and introduce yourself?
Sure. Now that I switched off that slide, hi everybody. My name is Chris Weger. I am a partner here at McMurray and Shuster. Lucky for me, I split my time pretty much evenly between compliance and litigation. So both kind of proactively help clients stay out of trouble, and then unfortunately, when issues arise, work with them in any litigation that results.
I would say we either work on the compliance side with clients or we see them later on the litigation side. So I think that that pretty much summarizes what you just said. But as we are not giving legal advice during this presentation, but we are more than happy to provide legal advice. So don't hesitate to reach out to us after the webinar if you have any questions or if there's anything we can assist you with. All right, so let's go ahead and get started with the first myth. And I hear this all the time. And I think, unfortunately, some folks are caught off guard and surprised by the fact with this first myth that B2B calls are exempt from the TCPA. And that is absolutely false. There are several provisions that apply within the TCPA, which has liability for businesses at a statutory level of $500 to $1,500. So important issue to understand. But there are several places where there is liability for business to business calls within the TCPA. You want to kind of give us an overview of that?
Yep, exactly. Happy to do so. So just very quickly to go through the bigger picture, under the TCPA, there are different aspects where claims can arise. On one deals with what we call regulated technology using an auto dialer, which, as we know, in the federal level under Facebook has largely been scaled back, but with threatened legislation, there's always the chance that this will kind of rear its head again. And there are also particular issues where there are concerns about using an auto dialer, but also artificial voice, which includes ringless voicemail, soundboard, those types of issues all require specific consent on outbound calls. And that includes in the consent level, and we have a nice little chart that Michele will go over in a second, talking about where that consent is required. But we'll have to think about, and we talk about text messages. When we do say calls, we're saying both, because really text messages are treated as calls. And when there is a distinction between a marketing and a non-marketing call, those mixed purposes calls are treated as telemarketing. If there's an underlying kind of sales campaign issue to it, then that applies. Now, the important thing is that these regulated technology claims, they strictly apply both to B2C, business to consumer, and B2B calls. There is absolutely no distinction there. And on the litigation side, there are a number of serial plaintiffs that can be either plumbing companies, chiropractor companies that are looking for these types of calls and bringing claims. So we are seeing actual class action litigation that is brought in the name of a business that receives these calls using regulated technology.
And I think it's a good time to kind of talk about why B2B calls apply when we start talking about technology. And it's because under the TCPA, it kind of breaks the compliance obligations to the type of telephone call or type of telephone that you are calling. So what kind of telephone line it is. And if it makes sense when you think about when the TCPA was written and that the real concern was how expensive it was to reach cellular telephone numbers. And that's why when we're talking about the regulations to B2B, we're really talking about, whether that telephone number, regardless of whether it's for a business or not, is calling to a cellular telephone number. And if so, we'll talk about those technology requirements that apply. But then also, even if it is a line that is used for business, the question is, and the litigation that we'll talk about, is whether it's primarily used for residential purposes. And then, unfortunately, that gets you to an area where you have to start talking about facts. how was that number used? And that has led to some interesting litigation recently.
Yeah, that reminds me. So TCPA is 1991. It was 14 years after the TCPA was enacted that I got my first cell phone. So
Don't even want to talk about that.
And we don't have to go at length over this, but just the marketing, non-marketing communications. It's important to remember, I think, to err on the side of a call being a marketing communication whenever there is an underlying sales goal there. So, so a lot of times clients say, oh, we're just calling with a reminder about something. But at the end of the day, we say, what are you really trying to do here? And if the answer is, we're trying to get a win back, we're trying to get a new sale, then I think we always want to err on that side, because the courts have been clear that anything that even has kind of a marketing tinge to it, they'll put in that bucket. And again, for what we're talking about here, regulated technology, that can bump it up into an area where a higher level of consent is required.
Yeah. And sometimes we'll be looking at campaigns, and while it does seem that it is primarily for a non-marketing purpose, if there is a contingency built in with how the reps are handling those calls, that they know what to do if somebody wants to just purchase something during that telephone call. I think it's a really important thing that you try to segregate those types of functions. So, let's say that you are calling for market research and someone's so excited that they really want to buy that product. Best to refer them to another place, like to a website or to a different agent that would handle marketing type of stuff. You really want to make sure you try to segregate those types of things, or just treat them as marketing calls. And so this is available on our website. You can go to the QR code or mslawgroup.com to our material section of the web page, and this will be there. And so basically, the consent discussion here for an automatic telephone dialing system is whether, or a pre-recorded message or artificial intelligence voice call, is whether we're calling a wireless number or a landline. And so if you're calling a wireless telephone number and you're not using an ATDS or a pre-recorded message, then no consent is required. And then you have to look to see if it is an ATDS or a pre-recorded message or regulated technology, whether that call is informational or telemarketing, as we were just talking about. If it's telemarketing, prior express written consent is required. We'll get into that in a little bit. If it's informational, it's prior express consent. For a landline, we really only have to look at whether the pre-recorded message is being used. And then again, it's the informational versus telemarketing. And if it's telemarketing, that same prior express written consent is required.
And the most important thing that, looking at this chart in our call today about B2B calling, there is no decision box that depends on, are you calling a business or are you selling a B2B product? So these rules apply just as much if you're calling a consumer to sell a B2C product as it would if you're calling a business, for some other service.
Yeah, excellent point.
Okay, so in addition to the calls using regulated technology, there is the federal and state do not call registry becomes an issue. And that applies even if you're not using any regulated technology. There are instances where if a phone number is on the DNC registry, you cannot call that number unless an exemption exists. Typically, callers to use that, they use either an existing business relationship. On the federal level, that means you have an inquiry within the last 3 months, or you have a transaction within the past year and a half, so 18 months, or prior express invitation, which is kind of the other side of the coin of consent, of prior express written consent. The standards are a little bit different, but as a whole, it's basically, through an online lead form or some other aspect, you are getting that written consent from the consumer for those calls, and that will override the DNC registry. So when people say there's the B2B exemption, I think, or not, from the TCPA, I think they're thinking about the do not call registry in general. And that is because the DNC registry, it applies to residential subscribers. So that's why people just say, setting aside regulated technology, that's going to equally apply. But even the do not call registry, this quote unquote exemption is not so clear. I'm not so fast right there, channeling my Lee course over there. But the issue here is that, under the TSR, which is a separate regulation, which we're really not getting into today, which involves what the kind of subject matter is of the call, what's being sold. The question is, are you selling a B2B product? The issue is whether or not the do not call registry restriction applies, that doesn't apply to what you're selling. It's how the person uses the phone that you're calling. And a lot of times that will come up then, as I think it's more common now than it's ever been, that people use either a cell phone or less so, but sometimes a residential or I mean a landline for both business and personal uses. And that becomes the difficulty is that when you're placing that call, you don't know how they use their phone.
Yeah.
And historically, we said, there is a strong presumption based on how that number is held out to the public. And that is, if there are websites listed where that phone number is listed for, ABC CPA, an accountant, then that's a really good defendable position. Unfortunately, in the past 3 years, there's been a decision out of the Ninth Circuit that I think kind of raises the risk level with this. And basically, what the Ninth Circuit held is that if a number is listed on the DNC registry, that creates a rebuttable presumption that the number is primarily used for residential purposes. And that means that the defendant then has the burden to disprove that. So again, if the number is listed on a website as a business number, you may have a good argument down the road that to defeat this rebuttable presumption. But the problem is, if you're subject of a class action lawsuit, that's going to be an area that's outside the pleadings. That means you're going into discovery, and that means that you could be litigating a case for 6 to 9 months before you can even address the question as to how this number is used. And unfortunately, we don't have to go through each of those, but the kind of the 5 factors that the Ninth Circuit outlined, a lot of these facts are things that you don't necessarily know prior to you're engaging in those calls, and you won't know until you do discovery. I mean, the third bullet point, how much the party used the number for business or employment purposes. Until you get those phone records and see who they're calling and how much, I don't know if they're using the phone 52% of the time to call their spouse and kids, or if they're using it 52% of the time to conduct business. Who pays for the phone bill? You're not going to know that till you subpoena the phone company. So that just leaves us in a place where, while in the purest aspect, the do not call registry exemptions are not going to apply in the B2B context. The problem is there's not necessarily a clear line where you're going to know when you're placing these calls, are you truly calling a business number or not? And that's the difficulty. And that's why we say we still need to be careful in placing these outbound calls because, and we'll get into this, depending on the lead source and other factors, I think, you can have a different level of comfort that you truly are calling a business number, but you don't necessarily know that. And on some level, there has to be thought in a contingency for there could be a portion of the numbers that we're dialing where this is somebody's personal cell phone number. And if they're registered on the DNC registry, that can open you up to litigation and a class action lawsuit.
Yeah.
So the silver lining that's good is we just talked about the Shinnett case from the Ninth Circuit, which was problematic because it says for that plaintiff, we are going to presume that that number is personal. That presumption, in these TCP lawsuits, the real danger is in the class aspect of it. The good thing is that many courts in looking like that say that presumption from Shinnett is not going to apply to the putative class members, the 20,000 other people that they're trying to base the recovery on. And the class certification has been denied, but a lot of these denials of class certification have fallen on the fact that, in talking about what's the reasonable expectation here, they talk about what's the source of these leads. So in this Payne versus Siva Networks case, the person got the lead, they were calling a motor semi-carriers, I don't know the exact term, but what they did was their lead sources, they went to the US Department of Transportation carrier listing and they found the phone numbers that were associated on that listing. And the court said, hey, on a kind of a broad brushstroke class certification question, we can say that if you're generally getting your numbers from that source, then the more reasonable conclusion is that these are going to be business numbers. But if you had a less reliable source where you got those listings, I think it's going to be a harder sell to get the court to say, we can deny certification because, we can easily state that that these numbers could be residential.
Yeah, I mean, it's important because it becomes that individual inquiry for each telephone number, like
Mhm.
you were talking about. And so looking at all of those types of surrounding facts are so critical too. If you can't get rid of a case prior to class certification, that you have these types of things to fall back on. So really important that you analyze
Yep.
all of the types of things that Chris has been talking
Yep.
about, and that you have that defendable position at the time that you are initiating
Yep.
these types of campaigns.
And so really the takeaway there is, the absolute safest course of action would be, even if you're doing a B2B calling campaign, would be to scrub against the DNC registry. And there always is this kind of functional question. I think each business has to look at the particulars of their campaigns and how they're running it. But, on one level, if numbers are registered on the DNC registry, maybe that's a signal to you that that's not going to be your highest yielding, leads there. And maybe that's not your best target audience. But there are instances, I think, where people are targeting certain businesses where, that doing that scrub will, could potentially remove a lot of
The numbers.
that are going to
Yeah,
be your best leads. So it's important, to think about that. And there, of course, is a cost in running the DNC scrub and
course.
that subscription. So that could also be a difficult, part of the calculus. The other issue too is, again, to that point, and I won't harp on this, but about, getting the list from the DOT listings as opposed to, just Google searches. Knowing your data source is important because, at the end of the day, especially if you're not doing that DNC scrub, you want to have some level of confidence that these really are truly business numbers, that are being sourced. And a lot of that too is going to depend on the last bullet point is, who are you calling, right? I mean, if you're calling 1-800 Walmart, I think you have a lot better confidence that you're calling a business number and you're not going to reach Joe Bag of Donuts cell phone. But if you're trying to market to, like, you're offering small business loans and you're looking at sole proprietorships, I think in that instance, there's a lot more likelihood that you are going to call someone who's just using their personal cell phone, for their personal use, and they've got the side hustle, and, maybe a couple days a week they're using their cell phone for that. So it's important to kind of take all these things in factor, and it really is based on the campaign, your target audience. It's really kind of customizing it and finding that risk profile that's going to be acceptable, because otherwise, we do see a lot of demands and lawsuits, that are coming up where, I mean, you see real estate agents are a common plaintiff here. It's businesses with tax credit, reaching out for that, small business loans. Those are areas where we're seeing a lot of TCPA class action lawsuits where the person's saying, you called me on my personal number, even though the company was solely trying to sell a B2B product and trying to reach a business. And they had no interest in reaching an individual.
And that is the crux of the issue with everything we're talking about today. Yeah, and so even beyond the federal regulations that we're talking about, the TCPA, the TSR, there are some states that don't exempt B2B calls. And so, just providing an example here on the screen, but it's important to know that while we have these issues on the federal level, when you dig a little deeper into the state level, there are states that don't even exempt them for the business to business calls. So scrubbing against those state do not call lists would be required. And it would be the federal list if the state isn't managing its own list, with most don't anymore. So just a whole nother level of complexity here when we're talking about B2B calls. Also, just another chart that we love. And again, this one's available on the website. Also can go to the QR code. And unfortunately, you can't see that on our screen. But basically, we are going through what the DNC analysis is. And, what's important here is we do talk about calls to business numbers and to residential numbers. And so it does say DNC scrub not required for a business number. Reference back all those comments, though, that Chris just made about knowing whether it's a business number or this is actually a residential telephone number. And then all of those consent requirements that we have been talking about apply for scrubbing against the DNC list.
Mm-hmm.
All right, myth 2. If a lead generator partner collected consent, we're covered, right? So
Yep.
no problem there because we got consent from the lead generator.
Yep.
Yeah.
And the answer to that, and this is not just B2B, but I think it does register there. The answer again, myth busted there.
Yeah.
And there are a number of issues that come with consent. And this is, a lot of these topics are interrelated, but the lead data quality and misidentification, to me, that's the big issue, in that we see a lot of in the B2B context, especially when we're dealing with targeting smaller businesses. I think people are getting a lot of our clients are getting extensive lead list of quote unquote business numbers, but they're not the most precise listings. And I think that, in reverse engineering, and unfortunately, when we have clients that have received either a lawsuit or a consumer complaint, we do some searching, like the person, they provide their phone number. Then when you search their phone number, you find out, okay, this phone number is listed on a MapQuest listing for a restaurant that's 7 years old, and that's the only place on the number you see it. So that leads me to wonder, hey, this lead source is just crawling the internet and just finding these, relationships between businesses and phone numbers, that aren't really there. So when a customer or a lead provider publisher, sources these things, I think you really need to look back and say, what confidence do we have with that? The other issue is when consent comes to the issue, and this kind of goes back to my question about, this is being a listing that was old. A lot of times people are pulling data that is kind of an aged lead, and maybe at the time it was associated with the business, and it's it is no longer. So I think that, and that goes to the issue of kind of reassigned number databases and whether to get into that. There's a lot of other issues that when you're dealing with age data, and whether or not that's still valid. And the other issue, I mean, if you do truly have consent on the federal level, consent does not expire. Some states' consent will expire. And the other issue is that if it would be an EBR that is serving as the basis to call, to the extent that that's needed, the EBRs also have a finite time period.
We should probably say that there are a lot of really great lead generators out
Yes.
there, a lot of really great marketers out there, and we work with a lot of them. But you're right, you really gotta do your due diligence on anybody that's providing you with those types of lists, because you live or die in the future on whether you can support and substantiate what's been provided to you in those lists. So really important that you make sure that you work with quality lead
Right.
generators and that you do your due
Yep.
diligence.
And I think that the misconception that either the TCPA doesn't apply or applies less to B2B calls
Yeah.
gives people who are engaged in B2B campaigns a little more what they feel like free license to say, hey, I'm just going to buy a bulk, list of 100,000 numbers for, a few $1,000 because, oh, these are just B2B calls. It doesn't matter. So I still do think that, um, there are risks that still remain with the B2B call. So I don't think that does just kind of give you that free rein to say, what we can, if this was a B2C call, I wouldn't trust this lead source. Oh, but just for B2B, it's okay. We see plenty of demands, plenty of lawsuits. So I just don't see the B2B just being carte blanche where you can kind of throw the standard rules out the window.
I love it that you included Bradley versus dental plans here. This is something that folks were really paying attention to when we were all looking at implementing the one-to-one consent rules at the end of last year and the beginning of this year. And the reason this became such an important issue is because this Bradley versus dental plans case dealt with not just what was required within the consent, but how you had to keep records of consent that's collected, and specifically whether you could collect consent through a verbal communication, so over a telephone and recording that telephone. And the court came back and said no. And this really rocked the telemarketing and lead generation world out there. So you want to talk a little bit about this case? And this is still relevant. This is not just an issue that was linked to the one-to-one consent.
Yeah, no, and it has huge ramification because it goes to both a kind of getting verbal consent over the phone. In addition, even online lead generation, it has open questions as to what is required to fully get the quote unquote e-sign consent, where on one level, these decisions and in decision lists can be read. There has to be a two-step process where on your lead form, you first have to lead someone fully through agreeing to e-sign consent and then getting consent for the call, which is an extreme position. I think could create extensive friction and that. So I mean, there are, I think there are different ways to approach that have various risk levels, but I'm definitely thinking about what is valid consent, and that for a B2B or a B2C call, this Bradley Dental Plans has really kind of shaken the lead generation world, or the outbound calling world, and I think it's just we're still trying to navigate and see what the ramifications will be.
Yeah, yeah, yeah. And the issue in this one was that, the court went through the process of what e-sign requires, and e-sign is very specific that you have to give those e-sign disclosures in writing before you can give the other disclosures for whatever it is you're trying to get consent for. So in the online lead space, that means that you've got to put an electronic disclosure statement there that meets those e-sign requirements, and the consumer has to kind of go through that process first. Checkbox probably next to it would be best. Lots of different ways that you could do that, and then the TCPA consent, and then taking that affirmative action or call to action, clicking the button basically to give consent for that lead. So important issue moving forward. Don't forget about the Bradley versus Dental Plans case as you're looking at your lead generation forms.
Exactly. And the other issue, which is a similar but a little bit different issue, is that for those of you who are getting using the publishers and buying call transfers, potentially where someone's doing the outbound calling and getting consent, it's surprising to me both, and talking to people in the industry and even seeing what contractual requirements are, is what I call the misconception that it's completely copacetic to do for a lead generator to place outbound calls and then get consent for a seller on that outbound call in order for the call transfer to occur. And really, when we go back to the TCPA, at the end of the day, the consent that's required is for the ultimate seller of the products, not the lead generator, not the publisher, not the call center that's placing the outbound calls. And there's a case that's about 2 or 3 years old now, Williams versus PillPack, that directly addressed this on point. And the court clear, and you can look at the language here, they shot down this idea that I'm going to place an outbound call, pre-qualify someone. And the idea here, right? I mean, that this was a publisher that did a pre-qualification step, not for a specific seller. They were calling for multiple, I think, sale opportunities, and they would transfer based on the qualification. It could be to anything from a hearing aid company to a health insurance product. It could have been anything, but what the court ultimately held is that they attributed those calls from the lead generator / publisher to the ultimate seller who the call was transferred to. So that's something that's important, that when you look at your contracts, if you are getting call transfers, it's not good enough to say, hey, if you're going to transfer calls to me, you have to get consent on that call before you transfer it. It is, before you place that outbound call, I have to be within that scope of consent that's granted, because that call either is or could be transferred to me. So therefore, that consent needs to be upfront prior to any outbound calling occurring, because through vicarious liability and other standards, that initial calling can be attributed to you. I mean, we see so many instances where the professional TCPA plaintiffs, or the people that are out there really actively looking for the cases, they play along, they wait, and they can go down a chain. They wait to figure out who's ultimately, and they'll sign up for a product, they'll sign up for an insurance plan or something, because they want to see, what agents have to do this, and they get them to email them, figure it out. And that's who gets sued. And then all of a sudden you see either a lawsuit or demand where you're saying, hey, you called me 50 times. And then the client, who's the ultimate seller, says, I only talked to this person once. But the issue is all those 50 calls and that maybe the publisher or someone 3 down the line did are all going to get attributed to them. So that's why important when we talk about this, if you're taking call transfers, make sure before any call is initiated that you're within the scope of that consent.
Yep, great point. Got to look at those lead forms. Got to make sure your name's on it. All right, myth 3. We don't use robocalls, so we're safe. And we've been talking about it. It's all about the technology, right? So
and
I
I
don't worry about anything else.
right.
So is that a myth?
The answer is, well, this is what this is kind of true, kind of false, and we're going to go into this. And the point here that I think is important that we're going to make on this, and I think, I guess, stepping back, right? I mean, the do not call registry, clearly it's false on that grounds, but it's also somewhat false on another ground, because maybe you are using robocalls and you don't know it. And to me, that this comes up a lot. And the thing that's important to think about here is that, I have surprise PRM, pre-recorded message calls. So as you remember, regulated technology includes pre-recorded voice or artificial voice. And I think that it is sometimes not widely known that there are technologies that fit within that definition that people don't necessarily say. So, a lot of times people are using offshore agents with soundboard, avatar, agency or technology, AI generated voice. Sometimes there is a live agent call, but then when someone doesn't pick up, they have integrated within their dialer or, some function where it's going to leave the voicemail drop only for people who don't answer. Say, no, we have live agents. We're not doing pre-recorded message. But when someone doesn't answer, if you are using the voicemail, then that will be a robocall. And the other issue too is sometimes before an agent gets on, there could be an IVR interaction, and that's not going to apply to the call abandonment disclosure. But if you have other kind of precursor pre-recorded voice that leads to the live agent, that could put you in the regulated technology bucket. And as a litigator, I've seen a surprising number of instances where a lawsuit happens and the client or someone says, hey, we don't use this technology at all. And then after a month of discovery, it finds out, oh, there was pre-recorded message that we had no idea about. It can sneak in there. And a lot of that is when we talk about call transfers, maybe there was a call transfer partner at the beginning. Either you were knowingly getting, warm transfers that were outbound initiated calls. Sometimes people are contracting for inbound calls only, but unbeknownst to them, there was an initial kind of outbound press one campaign that was kind of disguised as that inbound call. That involves those partners could have been using pre-recorded voice. I've had one or two other cases where agents, without telling anybody else on their own, set this up because they didn't want to sit there and leave the same voicemail over and over again.
Yeah, and this is so critical. There are so many people that have been surprised by this. And this is something that one of the assistant directors at the FTC called me specifically to point out, to make sure that this was something that we got out to the industry, that if an agent, even if they're using their own pre-recorded voice, and I feel like this sometimes happens a lot in the real estate kind of realm, but if they're using their own pre-recorded voice, so it's not one voice for every operator is using the same one. It's me recording my voice. I'm the one who's pressing the button when I get the voicemail, and it's leaving that message. They think, well, that should be fine. What difference does it make if I stay on the line with my voice and leave that message or not? Well, it makes a big difference, because under the laws, it talks about the initiating a call using a pre-recorded message, which is what happens with those types of calls. So don't be confused or overlook that as being something that is pre-recorded message.
Exactly. And the kind of the third point is related. Maybe it's just not the rogue agent, but a lot of these call platforms have this functionality. Maybe the left hand doesn't talk to the right, and that's activated. You don't know about it. And the last point that's is kind of an interesting one is I've had a number of lawsuits where a pre-recorded voicemail was alleged, and the basis of the allegation was I received multiple voicemails. They all sounded the same. They didn't use my name, like they were all generic. And at the end of the day, they were not pre-recorded messages. But it can be hard once you're in litigation, proving that negative. I mean, we actively try to do that, and that can be the difficulty. But, prospectively, taking steps like doing scripting where the messages are more personalized, where the person's name is used. Hi, Joe, this is Susie with ABC Corp calling, to leave you a message about this. That is going to not cause a plaintiff's lawyer or a demandant to go down that path of just assuming that the message is pre-recorded. So a lot of times, while I do feel confident that we can get you out early in those kind of instances by proving that wasn't used, you're going to be so much better off, proactively by using more personalized scripts so that people don't mistakenly assume that something is pre-recorded. Because I'm sure, agents, when they're just leaving messages over and over again, you can really get, in a routine and use the same intonation and everything. So just using that more specific scripting, I think, can just prevent that headache before it even comes up. And then the AI voice. You want to talk about that, Michele? Because we just have the prevalence of artificial intelligence calling now, and in addition to robocalls, there's just so many kind of new concerns that are coming with that, and it seems to be
Yeah.
all the rage.
Well, I think that when we're talking to clients about the TCPA and needing prior express written consent for this type of regulated technology, for a while there, I don't feel like so much anymore, but for a while there, they were very surprised that an AI voice was one that fit into this regulated technology. And I think it's because we were kind of lazy. And when we talk about the TCPA requirements, we talk about prior express written consent being required for pre-recorded messages. But what the statutes actually say is any telephone call that is initiated using a pre-recorded or artificial voice. So it clearly had always implicated that an AI voice was one that fit into this as well. But the FCC wanted to make this crystal clear. And so they came out in February of 2024 when they were very busy with their one-to-one rulemaking and the
Yep.
other types of things that they were getting out then. They ensured that folks knew that a pre-recorded message was an artificial voice was included as a pre-recorded message.
And the one caveat to that is that the AI generated voice is one issue. It comes that a lot of times people are talking about, AI generated texting interactions with people, right? We can have the smart texting. That if it's a true text output, then that's not going to be an artificial voice. So it really does deal with the audio voice that's made
Right.
to sound like a person
Right.
is speaking. So I think that that's important.
Yeah, a text can transmit a pre-recorded message using an artificial voice. So yeah, no, absolutely.
Mhm.
Or a pre-recorded message or an artificial
Yep.
voice. So yeah, important to remember. State requirements were on there and I just went right by
No,
them.
that's okay. Yeah, it was just
Yeah.
important to remember that, in addition to, a number of states have, we talk about, sorry, I can't
That's all
go
right.
back.
Utah is one of those, and Utah has got an interesting one because it's only regulates those companies that, or only applies to those companies that are regulated by the Department of Commerce. So think of folks like real estate agents. That's a common one in Department of Commerce. But there's a whole list of professions in the Utah law that talk or that apply to the Department of Commerce. A lot of those companies will be required to be licensed by the Department of Commerce, but they have some specific requirements for registering if you're using AI and are regulated by the Department of Commerce. Did I miss anything else on
Nope,
that slide?
no, that's
Okay, good. Anyway, so going to myth 4, time of day rules don't apply to B2B. This is another great topic, another area where we're
Yep.
seeing a lot of increased litigation.
Yep.
So, Chris, I
And I
think we already know the answer to that based on the answer to all of them.
Yeah, it's mainly busted, not
Uh-huh.
completely. So when you look purely at the TCPA, the section of the regulations where it does have the time limitations, which we see down there is from 8 a.m. to 9 p.m., those regulations are limited to a residential telephone subscriber. There is a subsection E under there, but it also extends those regulations to wireless numbers. And that references wireless numbers as discussed in a completely different FCC order. So it's very convoluted. But at the end of the day, our takeaway is that what this likely does is when we talked before about the do not call registry issue, it is kind of this wireless number approach really is, that mixed use issue, I think really could pull wireless numbers into this issue of the calling time restrictions apply. So, based on all this and, unless you have a compelling business reason otherwise, probably the best course of action, or not probably, the best course of action is to follow the calling time restrictions. And short of that, given that there is this added leeway in terms of wireless numbers, where you do have a business case of saying, maybe you are calling a business that's typically open at night or in the middle of the night, maybe looking at saying we're going to set our standards different from a landline versus a wireless number.
Yeah, it becomes difficult though, doesn't it, when we're talking about area codes, because they're no longer indicative of where somebody is. And so, some marketers are deciding to only make calls and place texts between that allowable time that is it meets all of the calling time restrictions, which is 11 o'clock to 6 o'clock Eastern time. It is interesting to think that Congress right now in committee is considering the Do Not Disturb Act, and it has in it a provision that would limit calling hours to only 5 o'clock. So it's going to be interesting to see what happens if that's where we land.
Yep. And the last point there that's important too is, while we generally talk about things on the federal level, there are states and which both don't have any, restriction on B2B in terms of these calling time restrictions.
Mhm.
And there are states that have more restrictive calling times. That could either be day of the week, or it could be, states have different holidays where they've held that, that the calls can be impermissible in certain circumstances. And there's some states like New York who create, kind of stated disasters, at which time it's impermissible to place any unsolicited calls, whenever those are declared. And that can be things that wouldn't necessarily be top of mind. And there it's
Gun violence was
yes,
one for
right.
quite some time.
And that was published on the AG's website.
Yeah.
And the presumption was that a business should check the website and understand that there's a kind of state of emergency declared, which restricts the ability to place those outbound calls.
Yeah.
So you have to think about the state level as
This
well.
applies to text messaging too, in
Yep.
case we haven't
Yep.
really pounded that. Some folks think that this is just calls, it's text messages as well. All right, myth 5, opt-outs are the responsibility of the vendor.
And that is debunked. So, really that falls into two different areas, which I kind of consider the same side of the same coin. And that can be that someone can either, by making we call kind of the DNC request, they can either be revoking consent, making an internal do not call request, or kind of quote unquote both. To the extent it's a revocation, that affects calls that require consent. So that's what we were talking about, where there is not that, generally speaking, the B2B or non-B2B distinction. So, using regulated technology, or some other issue, or if you're relying on a consent exemption, I guess, to place consent exemption for a DNC call, once that revocation occurs, that, it doesn't matter if you're B2B or B2C, that consent is revoked and must be honored, because the consent that you otherwise would have relied upon is now gone. Internal DNC is separate, and that applies, and again, under the regs, this is very similar to what we just talked about with the calling time restrictions. It deals with the residential telephone subscriber, but there can be a dialing back that for wireless numbers. So, so there is more of an open question about whether or not an internal DNC request, would fall under a purely B2B call if you're positive that the call is B2B. But either way, unless there's a compelling business reason otherwise, I mean, we generally advise if someone does something like, if someone says they don't want to be called,
Yeah, you should
maybe
probably
it's the type
stop
of
calling
person
them.
you shouldn't be calling.
Yeah, just that's a good business practice all the way around, regardless of compliance.
And the revocation of consent issue, that this has been I'm sure many of you are aware, kind of a start and stop issue with, the different orders that have come out and have now been delayed. But the key takeaway there is that, the consent, we always, I think, historically tried to push this idea that, a business on some level can kind of define what the can define what the reasonable means would be to revoke consent. So if you have an SMS program, text stop to stop, you say, we communicated, you had to stop, that's how you had to do it. But now, there has been a setback. Consent can be revoked via any reasonable means, which is kind of one of those squishy standards. Opt-outs within 10 days, I think that's, and I think, we always say try and do it quicker than that, because, under the pure TCP language, it says, it has to be revoked in a reasonable time up to 30 days. I think courts have said either that's a fact question, or, if you're using a texting, based program, with technology these days, that should be honored very quickly.
Yeah, I think we've already talked about this with the reasonable means, and the words that are in quotations are the ones that are seen as reasonable, but that should not limit what you're thinking of as a reasonable revocation request. And so those should be pretty broadly interpreted. I think that kind of that's common knowledge, and those need to be honored within 10 days. It used to be 30 days. So make sure that you get those honored within that time period. And then we don't want to forget about the importance of record keeping. The telemarketing sales rule on the FTC side. I just probably worth mentioning that last year they modified the telemarketing sales rule, and records need to be kept for 5 years. It used to be 2 years, now it's 5 years. So make sure you're already on top of that. But for specifically the IDNC, the internal DNC request, you have to keep all of this information when you are keeping those records of do not call requests. Let's see if we've got some questions here, because I think we have come to the end with our key takeaways.
Yep.
And
well, yeah, real quick. I mean, the key takeaways, I think, if you guys got anything, from this, my hope is I really put it in two buckets. The first bucket is that, under the purist model, when you are doing B2B calls, that, there still are regulations under the TCPA, state laws. Pure B2B calls still are subject to a lot of rules that you need to be cognizant of. And it's important, even though there may be some that don't apply, you still need to understand the rules that do apply. And the other issue too is that, how your campaigns are set up, who you're reaching, you also have to be thoughtful, can I safely put all of my calls, all of my text in that pure B2B bucket? Because, I think in a lot of instances, there are, there is a world where you're not, you are reaching people who are, it's not truly a B2B call that can raise some issues. So
about that, I was
No,
totally
that's-
distracting you as I was
Yeah,
trying
no.
to get to the questions and answers, and there we go.
Oh, there we
All
go.
right.
I found them. Here we are.
What about communications that start on web technology, like a web RTC, but escalate and then transfer to a phone? And so I'm assuming that when we're talking about those communications, we're talking about communications not in the form of how we're obtaining leads, but how we are communicating with folks. And so the question there, I think, really goes to the fact of whether the technology that you are using is an artificial or a pre-recorded voice. Or if there is anything in that dialing system that is randomly and sequentially generating the telephone numbers and then calling them. So I think that that's probably what we're getting at with that question. But Cliff, if not, reach out, and happy to further discuss that with you. It really is. It's whether it is one of those types of regulated technologies that would make a distinction.
And I would say those communications on, I mean, if it is a non-telephonic platform, whether or not, because there is a possibility that through those communications, you do obtain, an inquiry EBR, or some other, aspects. So, to me, that's kind of the other side of the coin where people say, hey, what if I get an inbound call and the person says they want to hear from me? Great, that can create an inquiry EBR. But if just a missed call, they say, oh, well, they were calling in, so I can call them back. So it depends on the substance of that communication and whether or not that communication then can provide either the consent or the exemption for a future call.
Yeah, yeah. And I would say that if you have an opportunity during that kind of web inter exchange or exchange at the beginning to follow our recommendations regarding e-sign, get consent, and then you at least have a fallback position there for any subsequent telephone types of calls.
Right.
What if the calling party is a member LLC that collected the consent online? It doesn't matter who collected it. The question is whether whether you're required to have consent for the type of call that's being placed. And then obviously being able to establish that as proof. And if it's a business, you need to still follow the requirements that we've talked about here. So the fact that it doesn't really matter who it is that's collected that at the beginning, all those same rules still apply. Do you want to talk about abandoned call rates for B2B calls?
That under the TSR, generally speaking, the abandoned call rates issuing a TSR does not generally apply to B2B calls unless you're selling durable office goods.
Durable office goods.
So generally the call abandonment rate issues will not apply under the TSR, but that does kind of raise the issue where there have been recent amendments to the TSR that do extend the UDAP, so unfair deceptive acts and practices standards, to B2B calls. So generally speaking, those types of things apply, but call abandonment issues would not apply.
Yeah.
On a B2B. And again, under the TSR, that depends on the products being sold, not who you're calling, which is the different standard than what we're talking about under the TCPA.
All right, would revocation in a reasonable means allow someone who has not given text consent to attempt to revoke consent by texting us via a landline number stop? Revocation by reasonable means someone who has not given text consent to attempt to revoke consent by texting us via a landline number stop. I don't know that I quite understand the question, but I'm going to interpret it this way, that regardless of what's happened here, however you've gotten that telephone number, if somebody is sending the message back stop or one of those other words that we had for what clearly expresses the intent of the consumer to not want to receive any more of those telephone calls, then yes, that would be a reasonable means. I don't know, is that the way you're reading that as well?
I think so, yeah.
Okay. Then would AI provision in HR1 change the use of AI voice regulation within the TCPA? I'm not familiar with HR1, are you?
I am not. We'll have to get back to you on that.
Yeah, Larry, we'll get back to you, or if you want to put something in the question and answers about that, happy to come back to that question. Confirming your position that the current rule for consent revocation is now 10 days. This was not delayed in 2000. This was not delayed until 2026. Yeah, that's the revocation of consent rules are in effect. Do you have a duty to confirm that a business number is indeed not a cell residential wireless telephone number? It's not that you have a duty to confirm that. It's just that you may be violating the law if you can't confirm that subsequently. So I would say it's not, I would say regardless of how you word why you should be doing it, you should be doing that. You should have that type of substantiation at the time you're making the telephone calls. If not, you could have some pretty serious issues.
Yeah, or the issue would be that, short of that confirmation would be to take other steps to limit the type of calling so that those calls would be permissible, even if it was to a cell or residential number. Things like scrubbing against the DNC registry and taking other steps. So
yeah, not using regulated technology.
Yep. So
yeah,
it's not that those types of calls are prohibited. It's just you have to know whether or not they fit in that bucket or not.
yeah, I think we have gotten to the end.
Yep.
Thank you guys so much for joining us this afternoon. I enjoyed working with you on this webinar and enjoyed listening to all you had to say. Don't hesitate to reach out to us if you have any additional questions, and look forward to seeing you at some future event.
Thank you.